Rick Esenberg. Good morning, Rick.
Good morning, Steve. How are you?
I am good on this Tuesday. So we know this. We know the history here. We've fought these battles before. A legislature does what they do. Governor, does what he wants to do. Obviously, politics is a big part of this. Both sides want to manufacture the lines, the districts, to make sense for their futures. What do you take away from the Wisconsin Supreme Court decision and then your decision as an organization, along with the legislature, to challenge that to the U.S. Supreme Court?
Okay, so I start with the assumption that partisans are going to act like partisans. So the Republicans are trying to draw the maps that will benefit them the most, and the governor is trying to draw maps that will benefit the Democrats the most.
Completely agree.
Going into the redistricting problem, the Democrats have a problem. And that is that they really need a court to gerrymander for competitiveness because their voters are way more geographically concentrated than Republicans. And if you draw a map and you don't think maps are going to vote for Democrats and Republicans, the Democrats are probably going to be at a disadvantage. And we brought a lawsuit initially because we felt that that was an inappropriate consideration, that there should not be a gerrymander to make up for the natural partisan disadvantage that one party has. And the court agreed with that. And it mandated a least changes approach. And so when we began the process of submitting maps, it was pretty clear that it would be very, very difficult for either party to substantially change the maps that were enacted in 2011. What happened is the governor, and I have to give him credit for this, the governor did two things. First of all, he decided that federal courts don't require maximum equalization of district populations when it comes to state legislatures.
Describe what that means.
So typically, the reason that we have to do this redistricting every 10 years is that the United States Supreme Court a number of years ago decided that legislative districts have to be equal in population. This is supposed to advance the principle of one man, one vote, so that if your district has twice as many people as another person's district, your vote is, not worth half as much. You don't want to do that. So the districts have to be equalized. And we do it every 10 years when the census data comes out. And when it comes to congressional districts, the federal courts have pretty much required that they be absolutely equal. Like, they can be off like one. Mm-hmm. But in state courts, when federal courts have reviewed state legislative districts, they've allowed more leeway. And so the governor allowed himself a little more leeway. He didn't make these districts as equal as he could have. And then he used the leeway that gave him to engage in, I think what is fairly described as partisan gerrymandering in the Milwaukee area. And what he did is he tried to spread black voters among seven legislative districts, seven assembly districts rather than six, and argued that he was doing this to comply with the Voting Rights Act, which under certain circumstances, not all circumstances, can require you to create minority districts. And all of these
does that argument make sense legally? Going from 7 to 6, although he's dispersing the numbers in those districts.
I think it does not, because there was relatively little change in the black population in Milwaukee. It went up by about 6,000. And by dispersing these voters, typically you would want to have a majority-minority district to comply with the Voting Rights Act if it were true that minority voters were facing some obstacle to participation. And so typically when you create a majority-minority district, because there's an obstacle to participation, it needs to be a supermajority. It's going to be maybe like 55, 60%, because it's premised on the notion that there's something that is preventing minority voters from voting. But when you do what the governor did here, is create 7 districts, which are basically 50.1% black majority, and he believes that he can win those districts, that Democrats can win those districts, and argues that black voters can elect candidates of their choice, he's essentially conceding that there is no barrier to participation. It constitutes a Voting Rights Act violation. And the Wisconsin Supreme Court didn't find a Voting Rights Act violation. It said, well, we think that it's a good idea to create 7 districts, but it didn't say that it was necessary to do so. in order to avoid a violation of the Voting Rights Act. And that's the issue. That's the issue that's being raised by the appeal to the Supreme Court that's been filed by the Republican legislators and our clients in the case.
Rick Esenberg joining us on WTMJ. I only got a couple of minutes, so I want to make sure I get this in. If you are successful at the U.S. Supreme Court, does it come back? What happens next?
I think it will come back, but we've asked in the meantime, because there have to be maps in place very soon in order to move ahead with the fall legislative election, that they use the legislature's maps for the time being. But ultimately, the case would be remanded, and the court would take a look at it again.
Always great to talk to you. I'm sure we'll talk down the line as this case progresses.